Now you may have seen the thumbnail to this video and then clicked on it wondering what exactly it's all about. And in order to explain what I mean when I'm asking the question, is sending nude images now illegal? I need to talk about something called cyberflashing. And the first question that probably comes to your head is, what is cyberflashing? Well, in this video, I'm going to explain the law surrounding this new criminal offence in England and Wales, and then go through what the maximum sentence is. Welcome to my channel, Andy on Crime, where I talk about high-profile criminal cases and other aspects of criminal law. And before I get into this video, if you do have any comments on this video, then please drop them down below. If you do enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. With all that being said, let's get into the video. So, what is cyberflashing? Cyberflashing is a new criminal offence which is the act of intentionally sending someone an unsolicited sexual image from your device to another person's device without their consent. And this can occur via social media, WhatsApp, Snapchat, Bluetooth AirDrop, or any other electronic means. And on the 12th of February of this year, Nicholas Hawkes became the first person in England and Wales to be sentenced for the offence of cyberflashing, having sent unsolicited pictures of his genitals to a 15-year-old girl. He was sentenced to 52 weeks in prison on the 19th of March 2024 and a further 14 weeks for other offences. So firstly, a bit of background to the offence. Now, cyberflashing, as I've mentioned before, is a criminal offence, and it's contrary to section 66A of the Sexual Offences Act 2003, and it's under the title sending etc. photograph or film of genitals. And no, I'm not getting that pronunciation wrong, that is actually the name in the statute, but it's more commonly known as cyberflashing. And it was introduced following the enactment of the controversial Online Safety Act 2023, which created the criminal offence. Now, this piece of legislation aims to impose rules upon social media companies to ensure that inappropriate and dangerous material is kept away from children and other vulnerable people. And this includes things such as self-harm material. And the law holds platforms such as Meta and Apple responsible for illegal content such as indecent images of children, as well as preventing the sale of drugs and weapons and revenge porn. And social media sites such as Snapchat and TikTok would also have to ensure that underage children are unable to create accounts. Now, the offence of cyberflashing is to a large extent the digital equivalent of what we would call exposure, which is section 66 of the Sexual Offences Act 2003. And exposure being something that occurs in a public place where someone intentionally exposes their genitals to another, intending to cause that person alarm or distress. And you will see some similarities between exposure and the new offence known as cyberflashing. And one of the main reasons for the introduction of this criminal offence was to put a stop to the extremely prevalent practice of women, particularly young women, being sent unsolicited pictures by men of their genitals. Now, there are clearly others that are victims of this type of offending, but this appears to have been the demographic most affected that the law was designed to protect. So let's get into the law behind cyberflashing itself, and I'll show a few screenshots on the screen of the legislation to assist you as we go through it. Now, under section 66A, in order to commit an offence, a person must firstly intentionally send or give a photograph or film of any person's genitals to another person. And there's a couple of things to unpick here. Firstly, the word send has been defined to include sending a photograph or film electronically, so via social media, via WhatsApp, via Snapchat. Showing it, as in you standing next to someone showing you their phone, showing it to a person on your phone, or leaving a photograph or a film for someone to find. And the second thing is, it does not have to be a photograph or film of your own genitals. If you send a photograph or film of someone else's genitals, then that would meet the first part of the offence. The second part of the offence can be committed in two ways. Firstly, the person sending the photograph or film of the genitals does so intending to cause alarm, distress, or humiliation. So that's one of the ways. And the second way is that the person sends the photograph or film of the genitals and does so for the purpose of obtaining sexual gratification, and they are reckless as to causing the recipient alarm, distress, or humiliation. So a couple of examples to explain. If person A was sending a photograph of his penis to person B, intending them to be distressed by receiving that photograph, then person A would be guilty of an offence. And the second example is if person A sends a film of a woman's vagina to a WhatsApp group for his own sexual gratification, and someone is alarmed by this, even if that was not person A's intention, then that would meet the definition of the offence. It is worth pointing out that as this law is brand new, there has not been any time for case law to have been developed to either limit or broaden the scope of this offence and provide parameters for this type of offending. This, as with all new laws, will take time as cases get appealed to the Court of Appeal and judgments are made on what does and does not constitute an offence under this section. So it'll be quite interesting, well, from my perspective at least, to see how the law develops over the coming years with regards to this type of offending. In terms of sentencing, the maximum sentence for this offence is 2 years imprisonment. And whilst it does not automatically lead to someone being placed on the sex offenders register, if someone is convicted and given any sentence of imprisonment or a community order greater than 12 months, then that person will be subject to notification requirements. And as you've already seen from the first person convicted for this offence, they were awarded 52 weeks in prison for 2 charges of cyberflashing. So to summarise, the criminal offence of cyberflashing is intentionally sending a film or photograph of someone's genitals to another person, and you do so either with the intention to cause them alarm, distress or humiliation, or you do it for your own sexual gratification and are reckless as to whether you will cause the recipient alarm, distress or humiliation, and it's imprisonable by up to 2 years.